Welcome to the Bankruptcy Matters interview series, organized and produced by the State Bar of South Dakota Debtor-Creditor Committee. In this series, you will hear from industry experts on the South Dakota bankruptcy process and how you can be involved in a growing area of the law. Please join us and our host, State Bar Past President Steve Huff, to learn more about why bankruptcy matters.
In this session of our Bankruptcy Series, State Bar Past President Steve Huff interviews bankruptcy trustees Leanne Pierce and Dale Wein on their observations of the Bankruptcy Bar in South Dakota and their advice for lawyers considering taking on bankruptcy work for their practice.
Thank you both for agreeing to talk with me about the issues raised by Judge Nail, and I think actually our Debtor-Creditor Committee and others, about what we see as a large wave of work coming toward the bankruptcy and debtor-creditor bars. Today I'm interviewing both trustees, Leanne Pierce and Dale Wein. Leanne, of course, is the Chapter 7 trustee. Dale deals in Chapter 13s, Chapter 12s, and we will acknowledge that those are different as we discuss some of the substantive questions we're going to ask. But I wanted to thank you both for volunteering and appreciate the time and the commentary for purposes of trying to offer tips and generate interest in these areas of the bar that will be very challenged by our farm economy and by this COVID economy that's coming, if not already here. So with that, I guess I would start with Trustee Pierce and ask if you would describe, for what in your experience is a good attorney in the bankruptcy court, good things that the debtor attorney does, good things that the creditor attorney does, and vice versa. And then I'll post the same question to Dale.
Well, as relates to either an attorney for a creditor or an attorney for the debtor, it's important to understand the law. And bankruptcy law is more complicated than some things, maybe not as complicated as others, but you do have to understand bankruptcy law, which is different than practice in state court. And that would be an important thing, first of all, for people for a good debtor or creditor attorney to understand. And it's important for that attorney to have a really good legal assistant, particularly for the debtor's attorney, because bankruptcy practice is paperwork intensive. And there's a mountain of paperwork that the debtor's attorney has to go through in order to prepare petitions and schedules. And if you have a debtor's attorney that thinks that they're just going to get started practicing in bankruptcy and not have any staff, that person is going to have some difficulty in making their practice be successful. A good legal assistant makes for a good attorney in many cases. And then that attorney needs to be detail oriented and be able to follow through, and to know that if you're looking at this schedule, you have to make sure that whatever you got there links over to this schedule and this schedule and that schedule to make everything flow. And that takes somebody that's willing to spend some time and pay attention to how the bankruptcy forms work. If you have your schedules completed properly, the rest of it will just flow. And that's really important.
Dale, what do you think? What makes a success? Go ahead.
I agree. The competency of the staff is what determines the quality of the office, I think, and of the product. And one of the things I tell new debtor bankruptcy attorneys when they're looking at doing their first couple of them, when you're going through the schedules, read the schedules. I mean, read what's in them. Don't just take the boilerplate that's printed out from the software package. Read what it is that they describe, or the types of assets that are supposed to be disclosed, things of that nature. Beyond that, I also encourage them to develop some sort of a network of other debtor attorneys that they can at least pick the brain of or bounce ideas off of. whether that's somebody else in the firm or somebody else in the office building that does bankruptcy work, or somebody you go to lunch with that does bankruptcy work, because there's a lot of common sense questions that sometimes have kind of a twist on them in bankruptcy. And I think it helps a lot to have somebody else that you can just pick up the phone or walk down the hall and say, you know, this just doesn't seem right to me. You know, have you come across this before? And going through that. And I agree with Leanne that the best bankruptcies are the ones where they have the best schedules that are prepared. But read the schedules even before you file them. Once you prepare them and everything, go through and read them just to make sure that they make sense.
Thank you. You know, the next question deals with the common mistakes that both debtor and creditor attorneys make. So do you think that's a product of, you know, maybe inadequately knowing the rules, biting off more than you can chew in terms of a more complex case that maybe your novice skill set is ready for? Or what do you think those common debtor and creditor mistakes are, and what would you like to tell those attorneys? Leanne?
I have done a couple of training workshops with debtors attorneys, not so much creditors, but I think the most important thing, and Dale might have already said this, is once you fill out your bankruptcy forms, your legal assistant uses the software and runs those forms and prints them off. You got to read the paper. What I think is a problem, a mistake, I'll be sitting in a 341 meeting with the debtor's attorney, and the debtor's counsel will say, oh, that's a software mistake. Well, I think when you're saying to the trustee, that's a software mistake, what you're really saying is, I never read the schedules myself. I just let the computer print them off, and that's what they say. You got to look at those forms and make sure everything adds up. And for a beginning debtor's attorney, the thing that I think most important on the schedules is take a look at your Schedule C. That's the schedule where you list your exemptions. Yep. And when you're talking about personal property exemptions, there really only should be 3 numbers that your personal property totals: 5,000, 7,000, or 12,000. And of course, that'll change if the state legislature changes those numbers. But if you've got a single person and it's over $5,000, you may have an error. If you've got a married couple and it's over $12,000, you definitely have an error. And so having both the legal assistant and the attorney looking at that Schedule C and seeing personal properties, either 5, 7, or 12, whichever one's right, and that your homestead exemption is 60,000 or 170 if you're over 70,000. If you've got a number that's different than those 2 numbers, that's a mistake. So looking at your Schedule C and reviewing your exemptions and making sure those are right, checking that math is so important. The other thing that I think is important is that if you are a new attorney going to practice bankruptcy law, read the local rules. We might have a set of the most comprehensive local rules in the nation, I think. That's what I hear anyway. And when you look at those, there are sample forms that the local rules committee that I think Dale sits on has put together. And so certain things, if you look at them, and for creditors in particular, creditors attorneys may not do a lot of motions for relief or motions for abandonment. I think both of those, there are samples in the book. There are samples of many things in the local rules. Reading those local rules can be really, really helpful. And I don't know what other trustees do. And I know you had said at the beginning that I'm the Chapter 7 bankruptcy trustee. I want to say there are 2 Chapter 7 bankruptcy trustees in the state. Forrest Allred also as a trustee up in the Aberdeen area. But when you're a bankruptcy attorney and the trustee says to you, you know, this isn't something that makes a difference for how I'm reviewing the case, but you might want to consider doing this differently another time. Listen to that, because that'll save you grief down the road. Don't just kind of blow that off. And I think it's important that when the trustee says, I need this, that, or the other thing, now this is the thing that helps me as trustee, but be timely. If the trustee says, I need a pay stub, I need a tax return, whatever, don't wait until the trustee has to file a motion for turnover to give you that. Those are the things that the code requires you to supply anyway. Just do it. And you'll find it's easier for you, it's easier for your clients. And the really good bankruptcy attorney, the people with experience, they come to the 341 meeting and they say, oh, I sent you that last week. You know, so think ahead, because usually once you've sat through a few 341 meetings, you know exactly what the trustee is going to ask. And you can be prepared in advance and have those documents to the trustee, and it makes a huge difference in the experience that your client has at their 341 meeting.
We have a very good bankruptcy bar, a very kind of a close one because there aren't a lot of numbers in it. But I think it's also important to realize that the debtor's attorney and the trustee are not necessarily adversaries. Where the trustees are many times trying to get the documents that are needed in order to administer the case. It's not being punitive or anything like that. As Leanne mentioned, I mean, there are suggestions that the trustee may make as far as how debtors' attorneys handle things in the future, in future cases. With Chapter 12 and 13 cases, we have a lot more, I think, ongoing communication with debtors' attorneys while the case is pending or while it's being administered. And what I find too many times is that debtors' attorneys or creditors' attorneys will also just file a document with the court and then hope and pray that it meets the court's scrutiny. I think the court also encourages counsel, whoever's drafting pleadings, to distribute the pleading amongst the trustee and the other creditors or the other counsel that are in the case to get their input as to phrases or provisions that may be needed or should be prepared a different way. The court is pretty set in its ways, I think, as to the way that our judge wants documents to be prepared. Just out of repetition, the trustee is the one who deals with those Monday, Wednesday, and Friday. And I would much rather have debtors counsel or creditors counsel send me a draft of a pleading, because it's 10 times easier to correct things or massage the language or things like that before it's filed with the court rather than afterwards. Because once it's filed with the court, if it's not in an acceptable format, then you may have to withdraw the pleading. You may have to file a motion to withdraw the pleading. Depends on who you have to then serve out notice on that motion to withdraw, only to get back to square one where you could have started with in the beginning. So I encourage the attorneys to circulate draft pleadings or documents to my office and to anybody else before they file them with the court.
You know, this applies maybe to both the first question, what's a good debtor's attorney, and what kind of mistakes do you see a debtor's attorney making? You know, a debtor's attorney has the same problem that all attorneys do when we go to court or when we're practicing law, in that we have an ethical duty to zealously represent our client. But we're also an officer of the court. And to keep that in balance. And I say from my perspective, I don't know what Dale thinks about this. If you're a debtor's attorney that I know that your stuff is done in good faith and you're not trying to pull something over, I maybe review your cases with a different level of scrutiny than I do those people that are not necessarily following their duties as officers of the court.
It's not an accident anymore.
Exactly.
It's a pattern.
Yeah.
That's right. Yeah, I agree.
All right. Well, do you have any legal resources that you think help keep you up to date? I know we've talked a little bit earlier about the local rules, and obviously those are both comprehensive and updated regularly, but do you think there are any other like national associations or CLEs? What resources would you suggest people looking at this area of practice look toward?
Well, there is the National Association of Bankruptcy Trustees, which really doesn't help debtor or creditor counselors. but it's really helpful for the trustees. Myself, I kind of keep an eye on the law list. I like the journal that organization puts out. The United States Trustees Office sometimes does seminars. I've heard Debtors Council talk about a bankruptcy seminar that occurs in Minneapolis every year, but that's more for council, and I haven't been to that, but I think it must be excellent because I hear people talk about that. There are training opportunities that are available, occasionally something through the bar.
I have been to that Minnesota bankruptcy seminar, and I think it's helpful because it's more of a nuts and bolts kind of a baseline thing for a lot of entry-level individuals. The other advantage that I know this year they're doing it is it's all online, so you don't have to travel to Minneapolis. Sometimes that's good or that's bad, depending on how my Twins or Vikings are doing at the time. I kind of have the same slant as Leanne, because probably the best resource organization that I belong to is the National Association of Chapter 13 Trustees. Obviously, that's not debtor bar or creditor bar. It's just an association of trustees. But through that, they have a national seminar and training with that. There's also a trustee listserv that we maintain. So if I come up with an issue from the trustee standpoint that I have questions about, or how someone else is handling, I can go to the listserv and basically send out a broad email to all of them to find out how other trustees have handled that issue. There's also, Leanne mentioned the U.S. Trustees Office, which is a good resource. We also have regional meetings with trustees, not only for our state, but also for the region, which includes North Dakota, South Dakota, Minnesota, and Iowa. And now it's every 2 years that they put on a seminar for those Chapter 12 and 13 trustees and address issues there. So we get the input from all of them.
When you talked a little bit earlier with the successful attorneys and their support staff, let's talk a little bit about each of your trustees' offices' support staff. And I apologize for slighting Forrest. I should have said Leanne is the Chapter 7 trustee I deal most with. I think I've had just a few cases with Forrest over the years, so I forget about that great line above which Aberdeen sits. But let's talk a little bit about the support staff that each of your offices have. Did you train them yourselves, or were you able to get them to lateral in? And if if your staff receives outside training, what kind and what is most helpful do you think? Leanne?
The woman who serves as my legal assistant for my bankruptcy work has been doing that since 2010. She works remote from Truman, Minnesota, and has for 10 years. She had a paralegal training. She is actually a legal assistant under the South Dakota Code. We did have one other young woman in our office that actually completed a vocational school bankruptcy program while she was here, but the U.S. Attorney's Office has hired her away from us. Anyway, how can they do that? Anyway, it helps to have training from the bankruptcy perspective. But on the other hand, if you have somebody, over the years, I've had multiple people that have served as my trustee's assistant. And what's most important is that they, understand how to do a caption, that they understand what a certificate of service is, that they understand how to track, that they're detail oriented again. I always tell my legal assistant when I hire a new one that their most important thing that they do is to nag me to get stuff done, because somebody has to be tickling my obligations and making sure that I don't miss a deadline. And a good legal assistant does that. I don't know how much of that is training or how much of that's inbred, but you need a good, whether you're a debtor's attorney, because I did debtor work before I was a trustee, whether you're doing debtor work, creditor work, or trustee work, you need that person that can do those kinds of things for you.
I have two staff people, program administrator and an assistant program administrator. The program administrator, her primary responsibilities are to run the specialized software that is set up for Chapter 13 trustees. There's about 3 or 4 different private companies that put that out. When I first started, we took over the software from the prior trustee, and I actually sent my staff person to Memphis, Tennessee for 2 days to just go through on-site training with that company, because the primary functioning in my office is the processing of payments in and dispersing those funds out and keeping meticulous records on all of those transactions. So that's a specialized software package that's only available from certain limited people, but we have since then just developed more of our own training on that software. So that's what my program administrator does. My assistant program administrator does some of the basic functions with that program, but it's more data inputting. She also is more of handling correspondence and emails and things of that nature. She had worked in the circuit court administrator's office here in Brown County for, I want to say 15 years, but before I hired her here, which helped a lot because she had a lot more common sense knowledge of court systems and court personnel, things of that nature. I also then sent my staff, I think it was for a half day or maybe it was a full day, after they were hired, to go to the clerk's office, whether it's Pierce, Sioux Falls, and listen to them, because as everyone knows, the clerk's office passes judgment upon all of the formats of the pleadings and, you know, captions and things of that nature. So I think it's important that they understand, you know, the details that are involved there, and also who it is they need to contact. Because as I stress to my staff, everybody's going to make a mistake.
Yep.
The question is, how quickly can you either recognize it, and how simply, you know, can we correct it? So I think it helps them to put a face on the people at the clerk's office as far as who they're talking to about what do they need to do to correct, you know, a typo in a pleading, or something else wasn't filed properly, or something of that nature.
What have each of you found to be financially rewarding and or professionally challenging, and what are the areas in particular that were posing the most challenges, whether it be a fraud kind of case, a management type situation? What advice would you offer based on those challenges to your replacements? Leanne?
Well, I have found being a trustee to be financially satisfying, and it's a good job opportunity for people that are interested in this kind of work. But the most satisfying part is you do have an opportunity to do a lot of different kinds of things in the law. And somebody that's interested in being a trustee should have a good background in the general practice of law, and have an understanding for family law, because sometimes an asset is going to be related to family law. Have a good understanding of probate law, because sometimes an asset's going to be in a probate estate. One of the most interesting cases that I had as trustee was about 9 years ago. I ran a dairy that had around 7,000 cows for 18 months. Okay, so that you might have that kind of experience. Probably my second most interesting case was liquidating a manufacturing plant in Salem, South Dakota, which had quite a bit of property and some things that you had to be really careful of because of laser printers and all of this kind of stuff. It is the variety that makes it, for me, be interesting. It's not like I'm doing the same case over and over again. You need to know different areas of the law, and you get a chance to look at all of those. And I find that to be professionally challenging and satisfying. When you ask what is the toughest area, the toughest area is probably not the legal issue, but the issue of when is justice blind? Okay, I'll have a debtor that truly is in a bad situation, that is over their allowed exemptions, and their attorney will say, you know, this person just can't do anything. It's just, this is a really, you know, bad situation. But you can't, as trustee, your obligation is to all of the parties, the creditors, the debtor, the court. You have an obligation under the statute to everybody, and all you can do is follow the law. If you're over on exemptions, you're over on exemptions, no matter what your situation is. And that is what I find personally difficult at times.
Well, I think what I find most satisfying or rewarding from a Chapter 12 and 13 standpoint is that I get to work, 98% of my time, I get to work with one judge, one clerk's office, albeit they're in two different locations, and there's a limited number of people there. And I think we developed a network to have a professional respect for everyone involved there. I also get to work with kind of a select number of attorneys who practice bankruptcy law. And my experience, 9 times out of 10, is that if everybody's honest with each other, we can resolve most any of the problems that way. I agree with Leanne. Sometimes it's tough because, my motto is that I need to handle the same issues or the same situations consistently. And sometimes that's hard to do, but it's the only answer, I think, is you have to be consistent, because about the time you start changing the rules, then the wheels just come off. And then I think it's out of control. So I think that's probably the hardest part that way. That, and with my cases, the Chapter 12 and 13 bankruptcies that I handle, I guess when I started as trustee, no one stressed the amount of accounting background that would have been helpful in doing that, because as they waited 2 years to tell me then, is that every year I get audited by federal auditors that come in, and there's no rounding up or down to anything. They look for every dollar and cent that's around, and it's my responsibility to account for that, which is fine. It helps because now in the last 12 years, they've developed a network through this national association of specialized accountants that basically will handle that for individual trustees. And that has simplified some of that I can basically utilize an outside accountant that understands the nature of Chapter 13 bankruptcies and what reporting is required by the U.S. Trustee's Office. All of the reporting and the auditing and things, the non-legal aspects, I guess sometimes are the most frustrating part of it.
Attorneys that are considering either re-entering the bankruptcy bar or debtor-creditor bar, or starting anew in that area, what words would you offer to those folks on the fence? Leanne?
Well, if you're talking about a law school student, take every code course you can. Nobody wants to hear somebody say that, but it's hard to learn that on your own after you're out of law school. You can go to seminars and you can read the code, but it's a lot better to have taken those code classes, because they do give you a much more background and depth to do this kind of work. It's just, that's the nature of bankruptcy. You need the code classes if you can get those. If you're going to start doing bankruptcy law and you're already a practicing attorney and you didn't do that, you might want to take some seminars. You might want to spend some time with the UCC so that you learn those kinds of things and what matters. And get a good background in general law. And I already talked about this a little bit. You need to know about family law because that might apply, or you need to know about estate planning because that might apply, or real estate law. You need to know those kinds of things that will help you be a good bankruptcy practitioner, to have a background from that. And then I've already talked about having a good legal assistant that would be able to help you. So those would be the suggestions that I would have for somebody that wants to start their own bankruptcy practice.
I would agree that I think that for me, the key would be the good legal assistant, because that's somebody who does the hands-on day-to-day information. If they have even a rudimentary experience in doing some of those in the past, that'll help out immensely. The code classes are good. I think also spend a weekend and read the bankruptcy code. You don't have to dissect it or anything, but so many times I think that I think the court decides a case and going back, starting with the black letter of here's what the code says. And there's all sorts of interpretations, I understand, but if you understand the basic format and fundamentals of that code, that'll get you a lot of the answers right away. And finally, as I said before, be willing to develop a little bit of a network for somebody that you can just walk down the hallway and bounce an idea off of, or a case that you've got for somebody else, just to get their second opinion on thoughts about where to go or what to do, or things of that nature. So I think that network also is very important.
I really appreciate your candor and your thoughtfulness in your remarks, but thank you both.